If you think you're safe because you have a carry permit and you've never committed a crime, this new ruling just changed the game for every gun owner who carries a smartphone. Today, June 29, 2026, the Supreme Court issued a 6-3 decision in Chatrie v. United States. Justice Elena Kagan wrote the majority opinion joined by Chief Justice Roberts and Justices Sotomayor, Gorsuch, Kavanaugh, and Jackson. That is an unusual coalition. 3 of the justices who sided with gun rights in Bruen and Heller, Roberts, Gorsuch, and Kavanaugh joined with the 3 liberal justices to establish a significant digital privacy protection. And the 3 dissenters, Alito, Thomas, and Barrett, were on the losing side of a Fourth Amendment case for one of the few times this term. Subscribe right now because what Chatrie establishes and what it leaves unresolved will affect gun owners, concealed carry permit holders, and every law-abiding American who carries a smartphone, which at this point means almost everyone. Let me start with the facts, because the story of Okello Chatrie explains exactly why this case matters to people who have never committed any crime. On May 20th, 2019, an armed robbery took place at a credit union in Midlothian, Virginia. The robber had been seen approaching from a corner of an adjacent church while appearing to talk on a cell phone. Witnesses gave descriptions. Surveillance footage was reviewed. But the investigation stalled. Police could not identify the robber. Weeks later, on June 14, 2019, local law enforcement applied to a Virginia magistrate for what is called a geofence warrant directed to Google. The warrant instructed Google to search its database and identify every cell phone within a 150-meter radius of the bank, centered on the credit union, for a period of time around the robbery. 150 meters is about 490 feet. The geofence covered a 17.5-acre area. That area included not just the bank. It included private residences. It included the church. It included anyone who happened to be in that neighborhood at the wrong moment. The warrant directed Google through a 3-step process. At step 1, Google would produce anonymized location data, with identifying information stripped out, for all cell phones within the geofence for 30 minutes before to 30 minutes after the robbery. The officers would review that data and attempt to narrow the list of suspicious phones. At step 2, Google would provide additional anonymized data for the narrowed list, covering a 2-hour window and including locations both inside and outside the geofence. The officers would narrow further. At step 3, and only at step 3, Google would turn over the actual identifying information, names, and phone numbers for the final narrowed list. Through this process, Google ultimately produced identifying information for 3 cell phone users. One of them was Okello Chatrie, whose location data showed he had entered the geofence approximately 10 minutes before the robbery and had headed toward a residential area immediately after leaving the bank's vicinity. He was subsequently arrested, indicted, and charged with robbery and firearms violations. Chatrie moved to suppress the geofence results, arguing that the warrant violated the Fourth Amendment. The federal district court held a full hearing. The district court actually agreed with Chatrie that the warrant lacked probable cause and particularity. The warrant was constitutionally defective, but the court admitted the evidence anyway under what is called the good faith exception to the exclusionary rule. The good faith exception says that even if a warrant is later found defective, evidence obtained under it is generally still admissible if the officers genuinely believed they were acting under a valid warrant when they obtained it. The district court found that the officers acted in good faith. Chatrie was convicted. He entered a conditional guilty plea, preserving his right to appeal the suppression ruling. The Fourth Circuit affirmed. When the full Fourth Circuit reheard the case en banc, it split 7-7 on whether a Fourth Amendment search had even occurred. Of the 7 judges who thought a search had occurred, most still let the evidence in under the good faith exception. Chatrie petitioned the Supreme Court. The Supreme Court took the case on a specific and limited question. Did the police conduct a Fourth Amendment search when they obtained Chatrie's location data through the geofence warrant? If you are finding this important, subscribe right now. Because what the Supreme Court did and did not decide in Chatrie has immediate and lasting consequences for every person whose phone creates a location trail through the digital world. The answer to the question the Supreme Court took is yes, and it is an unequivocal yes. Justice Kagan's majority opinion begins by explaining what a geofence warrant is and what makes it constitutionally distinct. Police have always been able to ask witnesses who was in an area. They have always been able to review surveillance footage. They have always been able to follow physical evidence. But a geofence warrant does something different. It asks a technology company, in this case Google, to search through the location records of hundreds of millions of its users to find the ones who were in a specific place at a specific time. It is a reverse search. Traditional investigations start with a suspect and search for evidence. A geofence warrant starts with a place and a time and works backward to find suspects. As Kagan notes, it creates the possibility of identifying and investigating everyone who was anywhere near a crime scene, including people who had nothing to do with the crime. The government's main argument was the third-party doctrine. Under the third-party doctrine, if you voluntarily share information with a third party, you have no Fourth Amendment protection in that information. The government argued that Chatrie voluntarily shared his location with Google by using a phone with location history enabled. He chose to let Google collect that data. Therefore, he surrendered his privacy interest in it. The Supreme Court rejected this argument decisively. Kagan explained that location data is different from ordinary third-party information like bank records or phone call logs. Your location over time reveals intimate details of your life, where you go to church, where you receive medical treatment, where you attend political meetings, what organizations you join, whether you attend gun shows, gun ranges, or Second Amendment rallies. This information, Kagan wrote, is the automatic price of conventional cell phone usage. Nobody consciously decides each moment to share their location with Google. The apps on the phone are doing it automatically, continuously, without any specific intentional act by the user. That is not the kind of voluntary sharing that strips away constitutional protection. The majority relied heavily on Carpenter versus United States, the 2018 landmark case in which Chief Justice Roberts wrote the opinion holding that the government needs a warrant to access cell site location information from wireless carriers. Carpenter established that long-term tracking of a person's location through cell tower data is a Fourth Amendment search despite the third-party doctrine. Chatrie extends Carpenter. It holds that even shorter duration location data from Google's far more precise location history service is also protected. The majority addresses the government's argument that Carpenter only applied because it involved 12,898 data points spanning 129 days, while the geofence warrant in Chatrie covered only 2 hours. Kagan rejected any such bright-line temporal rule. An individual has a legitimate expectation of privacy in records about their cell phone's location, and police intrude on that interest when they demand the information, even if only for a limited period, even if from a third-party tech company. Hey, 73% of people watching right now are not subscribed. This ruling matters for everyone who carries a phone, and that is essentially everyone. Subscribe right now so you understand every development that flows from this decision. Now, let me explain why Chatrie matters specifically to gun owners and concealed carry permit holders. Think about what a geofence warrant actually sweeps up. It captures every phone in a geographic area during a time window. If a crime occurs near a gun show, everyone at that gun show has their location data potentially captured. If a crime occurs near a gun store, everyone who shopped there, browsed the aisles, or stopped by to pick up an order has their data in the geofence. If a crime happens near a shooting range, everyone who was at the range that afternoon is in the dragnet. If a constitutional carry event, a Second Amendment rally, or a political gathering is held near where a crime later occurs, every phone that was at that event is in the geofence. Before Chatrie, the law was unsettled on whether the government needed to satisfy Fourth Amendment requirements before issuing these warrants. Some courts said yes. Some said the third-party doctrine meant the government could get this data without probable cause or a valid warrant. After Chatrie, the rule is clear. The government must get a warrant. That warrant must be supported by probable cause, and that warrant must describe the search with particularity. A warrant that simply says, give us everyone within 150 meters of this location for 2 hours is very likely insufficient on particularity grounds. The Fourth Amendment requires the government to describe the particular thing to be searched and the particular people or objects to be seized. A broad dragnet that sweeps up everyone in a neighborhood does not obviously satisfy that requirement. But here is the most important thing about Chatrie that most coverage is getting wrong. The ruling is more limited than it appears. The Supreme Court did not suppress the evidence in Chatrie's case. It did not declare his conviction invalid. It did not hold that the warrant in his case was unconstitutional. It sent the case back to the Fourth Circuit to answer those questions. Specifically, the Fourth Circuit must now determine whether the warrant satisfied probable cause and whether it satisfied the particularity requirement at each of its three steps. And the good faith exception still hangs over the case. The district court already found that the officers acted in good faith. That finding has not been reversed. Even if the Fourth Circuit now finds the warrant defective on probable cause or particularity, it still has to decide whether the good faith exception saves the evidence. That question may produce the same result, that the evidence comes in despite the warrant's defects. This is what Justice Alito's dissent focused on. Alito argued that the Supreme Court should have either dismissed the case or simply upheld Chatrie's conviction based on the good faith exception, since the full Fourth Circuit had already held that Chatrie could not overcome that exception. He said the majority's ruling sends seismic waves through Fourth Amendment law while producing no actual result in the case that prompted it. He also pointed to something important. Google has already modified its location history service. The traditional three-step geofence process the warrant used in this case has been foreclosed by Google's own technical changes. Google now stores location history data directly on users' devices, rather than in Google's centralized Sensor Vault database. Police cannot compel Google to search its own database for users in a geographic area because that data is no longer in Google's database. It is on the phone itself. This creates an interesting practical reality. The specific geofence technique that Chatrie addressed may already be obsolete with respect to Google, but the Fourth Amendment principle Kagan established is not obsolete. Other companies, Apple, Meta, Snapchat, Uber, Lyft, fitness app companies, retail apps, dozens of other data holders continue to collect location information. The geofence warrant technique can be directed at any of them, and Chatrie's holding that location data is Fourth Amendment protected even when held by a third party covers all of them. Law enforcement who wants location data about everyone in a geographic area from any of these companies now faces the same constitutional requirements the majority established in Chatrie. The digital dragnet, wherever it is pointed, requires a warrant that satisfies probable cause and particularity. Let me now explain the practical takeaways for gun owners specifically. First, if you attend a gun show, a gun range, a firearms retailer, a Second Amendment rally, or any other gathering and there happens to be a crime in the vicinity, your phone may generate data that law enforcement could seek. Before Chatrie, the legal protection against that data being obtained without constitutional process was less certain. After Chatrie, that protection is confirmed. Law enforcement needs a warrant. The warrant needs probable cause. The warrant needs particularity. A broad geofence sweeping up everyone in the area does not automatically satisfy those requirements. Second, even with Chatrie's protection, the good faith exception remains a real limiting factor. If law enforcement obtains a geofence warrant that is later found defective, but obtained it under a genuine belief it was valid, the evidence may still come in. The decision whether to suppress turns on both whether the search was constitutional and whether the officer's reliance on the warrant was objectively reasonable. Chatrie only resolved the first part. The second part still has to be litigated case by case. Third, know what is still on your phone. The ruling in Chatrie addresses location data held by Google, but your phone generates location data for many apps and services. Maps applications, ride-sharing applications, food delivery services, fitness tracking, weather applications, social media applications that tag your location. All of this data sits in various corporate databases. The Fourth Amendment principle Kagan established covers them, but each will require its own litigation to confirm. For now, the protection is confirmed as to location history of the type Google collected. Broader application will develop over time. Fourth, understand that Chatrie does not give gun owners any special protection beyond what every other American has. It gives everyone the same Fourth Amendment protection against location data dragnets. That is actually the right outcome. Gun owners should have the same rights as everyone else. And after Chatrie, everyone has the right to know that when police want to identify everyone whose phone was in a geographic area during a crime, they need to satisfy the Fourth Amendment first. The broader significance of Chatrie is its place in a line of cases that have slowly adapted the Fourth Amendment to the digital age. Katz versus United States in 1967 held that the Fourth Amendment protects people, not just places, and established the reasonable expectation of privacy test. Riley versus California in 2014 held that police cannot search the contents of a cell phone during an arrest without a warrant. Carpenter versus United States in 2018 held that cell tower location records are protected despite the third-party doctrine. And now Chatrie in 2026 extends that protection to the more precise, shorter duration location data that geofence warrants seek. The court is building a framework that recognizes the constitutional stakes of digital surveillance. Location data is intimate. It reveals who you are, where you worship, how you live, what you believe, and what you do. The government does not get access to that information without satisfying the Fourth Amendment, regardless of whether it is held by you or by a technology company that collects it automatically when you use their services. Here is your practical action plan. 1. If you are currently facing charges in a case where a geofence warrant was used to identify you as a suspect, contact a criminal defense attorney immediately. Chatrie's holding is retroactive in the sense that it applies to pending cases. Whether you can use it to suppress evidence depends on whether the good faith exception applies, which requires a fact-specific analysis by an attorney. 2. Understand that the ruling does not mean police can never obtain your location data. It means they must get a warrant that satisfies probable cause and particularity. If they have evidence that links you specifically to a crime, they can get a valid warrant for your location data. The ruling targets the dragnet, not the targeted investigation. 3. Think about the location permissions you grant to apps on your phone. While Chatrie's protection applies regardless of whether you consented to data collection, you can reduce your digital footprint by being thoughtful about which apps track your location and when. 4. Follow the further proceedings in Chatrie's own case. The Fourth Circuit must now decide whether the warrant in his case satisfied probable cause and particularity, and whether the good faith exception saves the evidence. That ruling will provide additional guidance on what a constitutionally valid geofence warrant looks like. Subscribe right now, because the Chatrie decision, decided today alongside Trump versus Slaughter, closes one of the most active Supreme Court terms in decades. I will have complete coverage of the Fourth Circuit proceedings when they issue and any further developments in digital privacy law as it intersects with law enforcement and your constitutional rights. This is educational content only, not legal advice. For any situation involving a geofence warrant or any other digital surveillance in a criminal matter, consult a qualified criminal defense attorney who understands both Fourth Amendment law and digital privacy immediately.